Okay, so this is chapter 15, which is all about ethical and legal issues in abnormal psychology. All right, so in terms of deciding kind of what is considered to be ethical within the field of abnormal psychology, we use the APA Ethics Code, which is the American Psychological Association's Code of Ethics. And within this code of ethics, there are various standards that we as psychologists need to follow to help us resolve these ethical issues. So we'll talk about some of these specific ethical issues, and failure to follow this particular code of ethics can result in some pretty strict sanctions for psychologists, including things like loss of your license, which would result in inability to practice. So there's some pretty serious consequences for psychologists who do not adhere to the ethics code. So within the ethics code, there are guidelines for all kinds of things, right, as they relate to the practice of psychology. We will focus on the ones that are the most relevant to abnormal psychology, but as you guys can see here and from the previous slide, that there are also a lot of aspects of the ethics code that might not necessarily be seen in the field of abnormal psychology, but they apply to other areas of psychology as well. All right, so one of the things that we are looking at in terms of the ethics code here that applies directly to abnormal psych is this idea of what's called competence. So psychologists basically have the competence to do forms of assessment, to be able to do case conceptualizations, which we've covered in class before, and also to provide interventions for clients. Psychologists may also have the competence to provide what's called expert testimony. So in expert testimony, you're basically tasked with providing testimony about things like maybe the limits of eyewitness memory in terms of kind of remembering the details that may have happened in some kind of crime. You might also be asked to provide testimony about what's a kind of typical course or what would be expected from a person who's showing a particular psychological diagnosis. You may also be asked to get involved in evaluations for Child Protective Services, or in Pennsylvania, it's Children and Youth Services. So you may need to basically do evaluations, potentially of caregivers, so think parents, to determine things like, you know, is it necessary to maybe have these children taken out of the home? Is it necessary to maybe have these children placed in foster care? And these are concerns that are directly related to the welfare and the well-being of the child. We may also need to provide information on what's called providing a guardian ad litem. So with the guardian ad litem, this is a person who is appointed by the court to represent or make decisions for a person who is legally incapable of doing so. So this is basically where a psychologist might come in and actually make decisions on behalf of a person who is not capable of making those decisions for him or herself. And so in terms of looking at competence on the whole, the American Psychological Association, or the APA, has developed some specific guidelines for clinicians to use, especially if they're asked to provide kind of guidance maybe outside of their field of expertise. So for example, I am a child psychologist, so I would have competence to work in areas that are directly related to working with children, but I may not have the competence to be, let's say, doing evaluations or expert testimony if it's maybe adults with schizophrenia. So the APA provides guidelines to help you kind of make an informed decision about areas that are outside of your professional expertise. All right, so as psychologists, we are also tasked with providing consent and also confidentiality of information. So before any client begins therapy, the clinician is required to provide clients with some kind of informed consent statement. And it's a written statement that outlines several things. So first, it'll tell the client about the goals of treatment, the process of therapy, the client's rights within the therapeutic context. It'll also, though, talk about responsibilities of the therapist. So what is the therapist going to do in this particular situation? It will tell about risks of the treatment, any specific techniques that the psychologist may use in treatment, what the client is actually going to pay, and then also the limits of confidentiality, which takes us to the second half here. So within the client-therapist relationship, we have something that's called privileged communication. Privileged communication basically means that the clinician the psychologist, cannot disclose any information about the client in court without the client's expressed permission. So the client has to give some kind of permission. It's typically called a release or a release of information. And then the client is basically saying, it is okay for you as my therapist to share what I have told you in session with people outside of just the two of us, right? Outside of that client-therapist relationship. There are, however, some limits, so some exceptions to confidentiality. So in cases where we suspect that there is any kind of abuse that is going on, we are required to report that, and that's something that's called mandated reporting. So this applies essentially to anyone who works with children who are under the age of 18. If you suspect that there is abuse going on, you are mandated, meaning required by law, to report any suspected abuse. We're also required to report, cases where we think that perhaps the elderly, right, are being abused also. So you are required by law to do that. So that's one exception to this confidentiality. We also need to, in some cases, break confidentiality when we have what's called a duty to warn. And this is based on what's called the Tarasov case. And so essentially in the Tarasov case, this is Tarasov versus the Regents of California. And Tatiana Tarasov, her parents brought this case where they're basically suing the state of California's Department of Education because their daughter was murdered by someone who was receiving psychological help in one of the University of California counseling offices. And the therapist did not warn Tatiana Tarasov that her former boyfriend was basically making threats on her life. So within that particular context, we are required as psychologists to warn when a specific person is identified as being the target of one of our clients' kind of aggression, right, or aggressive impulses. So if a person says to you, like, I intend to kill Mike Smith, then our duty is to warn Mike Smith. So that oftentimes involves, including the police and law enforcement in that capacity. It has to be a specific person, though. If your client says, I feel like killing people, that's not a specific person. That would not be a case where you would then break confidentiality. But if it is a specific person who is identified, then we have a duty to warn that specific individual. All right, so we also have what are called multiple relationships when we're looking at kind of the ethics that surround the relationships that we may have with our clients, with our students, and then also with research collaborators. We will focus here on clients. So multiple relationships are basically some kind of unethical relationship that happens when the psychologist is in a professional role with a person and then has another role with that same person. So the idea here is that, let's say I am seeing someone in therapy, right? I am the psychologist and I'm seeing my client in therapy. And then I find out that this client is also on the PTA at my child's school. And I have to work with this client in that particular relationship as well. That's a problem. And it's a problem because it could potentially impair my objectivity, my competence, or my effectiveness in terms of working with this person. Maybe I could potentially start exploiting this person, right, for my own personal gain, and that would clearly be unethical. So in that particular sense, then, psychologists need to be very, very careful about setting up specific boundaries with clients. So boundaries are kind of a line of demarcation, right, that outline, these are my professional responsibilities to you as your psychologist, and we're not going to have a personal relationship, we're going to have a professional or a business relationship. And the boundaries are really aimed at protecting the client, right? I mean, that's the main goal here, is to protect the client. So for these particular boundaries, then, you want to be able to refrain from having any kinds of conflicts of interest. And then you also want to refrain from exploiting people in any capacity. So thinking about this, I mean, the client is in a very vulnerable position, right? I mean, they're seeking help, they're seeking some kind of assistance. Typically, they're coming to therapy sessions with a lot of problems. And you, as the psychologist, you have a lot of power. And so it is incumbent on you to make sure that you are not exploiting your clients. One of the ways that exploitation can happen is in terms of sexual exploitation. So for a client, having any kind of sexual relationship between client and therapist is clearly out of bounds. The APA Ethics Code states that after therapy has ended, you must wait at least 2 years. So 2 years before it would be considered ethical to then have a sexual relationship with a client. My advice to you, though, is to never have sexual relationships with clients, current or former clients. It's an unequal balance of power, and I think it is exploiting the client. All right, so we're going to talk a little bit here about some of the legal issues that are involved in providing services for clients, especially within a court capacity. So some things that may happen as you are working with different clients. We have something that's called a commitment procedure. So with a commitment procedure, this is basically an emergency procedure where I have, as a psychologist, determined that this particular person is a danger to him or herself, or is a danger to society at large. And so this person must be committed or involuntarily kind of restrained or committed, checked into a psychiatric hospital. So within that particular hospital setting, then, clients do have certain rights, right? So they have the right to treatment, they have the right to receive that kind of appropriate level of care within that hospital setting. They have the right for liberty, and then also to get some kind of safety, right? So this is the right to move about the psychiatric hospital, and then also the right to receive protection from violent patients. They also have, though, the right to refuse treatment, right? So they can refuse treatment as long as they are capable of giving or withholding their informed consent. Okay, so they should get some informed consent procedures done before they actually agree to any kind of treatment. And then we're also looking at what's called a least restrictive environment. So we're essentially going to provide kind of the most free-flowing environment for the client that is possible. So clients should not be, for example, locked in solitary confinement. That is a very restrictive and probably abusive kind of environment, and that is clearly not in the best interest of the client. All right, so some forensic issues that come to play here. So you guys have probably heard people declared not guilty by reason of insanity. So what does that actually mean if we're looking at the intersection of psychology and the law? So the idea here is that the individual person, so the client, because this client has some kind of psychological disorder, this client cannot be held legally responsible for his or her criminal actions. The idea is that the client cannot understand kind of the legality behind what happened. They cannot understand kind of right or wrong behind the actions of what they did, and so therefore they should not be held responsible for committing the certain crime. We may also look at something called determining a client's competency to stand trial. And so this is where psychologists might make some kind of prediction about essentially kind of, can the person understand the charges that are brought against him or her, and can the person be kind of willing to work in their own defense? So will the person be able to kind of understand the nature and purpose of a death sentence, for example, if that is something that could happen as a result of a particular court ruling? Does the person have the cognitive, emotional, social stability to be able to withstand a trial that may be dragged out over months, potentially? All right, so in terms of just general conclusions here, psychologists need to know about the law. They need to have a pretty solid understanding of how mental health issues are dealt with within court systems, within legal proceedings. So they really do have to work pretty closely in many cases with legal professionals, and it seems that this particular area of psychology will continue to grow as the field continues to develop.